iPhone in as well.
So I'm not going to use I can't use my ear thing, so hopefully there won't be any feedback because.
And we are live. More than just a seat in a classroom, learning with friends and staying in your zone. These are some phrases that we're going to be talking about today when we're discussing a new important decision that just came out of the Sixth Circuit Court of Appeals. If you are new to our show, I am Charmaine Tanner. I'm a parent, an advocate, a retired teacher, and author. Where's my book? Of a #1 selling book on Amazon that is called The Art of Advocacy, a Parent's Guide to a Collaborative IEP Process. So if you would like to get a copy of the court decision that we're going to be talking about today, all you need to do is type in the comments the word decision, and my IEP bot will send you the link to the actual circuit court decision. So today we are so lucky because we have two guests with us today. And with the magic of technology, our guests are going to be appearing with us. And let's see, let's bring Kim over here. And Kim is also with Justin Gilbert, who is the attorney in the case. And Justin is with us via Facebook. So we have a few different ways to bring people together. Kim is with us live. Justin is with us live through FaceTime on the phone. So we are creating new ways of bringing people together today. We like this. One of the things when I was reading about the recent court case is I loved this statement that Justin gave in response to the decision, and I wanted to share that with you. He said, "The law of Tennessee, Michigan, Kentucky, and Ohio will bear his name, reminding us all that kids with intellectual disabilities belong. They are to be included, and we are all better for it." So I know this is a value that resonates with our viewers, and I want to welcome everybody who's with us live. Any questions that you have, type in the comments and we can bring those up. And I also wanted to introduce Kim. Kim Kredich is an advocate from East Tennessee region for the Special Education Advocacy Center. And she has been involved with Luka, the student, and his family ever since Luka was in pre-K class, which happened to be a segregated class. And through Kim's advocacy efforts, she was able to help support him, and he was fully included in kindergarten. She has worked with the family throughout the years, even attending the 7-day trial and traveling to Cincinnati recently this summer with her family and her son, Ben, who happens to have autism. And she was there for the oral arguments at the Sixth Circuit Court. So I am excited. I want to welcome you both and know that we are just very excited to be able to hear some of the background of the case and also the summary of the decisions. But I think probably what a lot of our viewers are wanting to know is about how this can impact other students. And I know particularly in those, states in the Sixth Circuit Court, but also for families around the country and how this can be used in supporting their students' journey for inclusion. So welcome again to both of you. And Justin, do you want to start us out maybe talking about some of the, just some of the background facts about the case? Tim, if you could hold him a little higher because we've got your name there, which I'm not sure how I can get rid of. There we go. All right. Hey, Justin.
Can you hear me okay, Charmaine?
Yes, perfect.
Okay, great. Yeah, I'll tell you a little bit about the background. The parents of Luka actually began pro se, which means they represented themselves without a lawyer at a due process hearing. I was not involved at all initially. I actually read about the due process hearing going on in our local newspaper. And so because it was an open hearing, I dropped in just to see what was going on because I was interested and I frankly admired the parents who would take this on themselves. The mom was doing an outstanding job, and during a break, I told the father, I said, if this doesn't go your way and I can help you once you get to the next level, please let me know. And the father, Greg, just gave me a hug and almost cried and said, thank you so much for the help. We've not known where to turn. And so, sure enough, the due process hearing did not go the way that the parents wanted it to. And so they turned to me at that point, and it was my job to get this from due process into the courtroom, that is federal court. And it was at that time that the parents, Deborah and Greg, introduced me to Kim and told me of all of her advocacy. And we began putting together a team, me being the lawyer, Kim the advocate, very knowledgeable and interested parents. And that sort of began our journey into federal court, a journey that would take 5 years. But that's how the case got started, Charmaine.
And I think that is, like you said, for parents to be able to take a due process hearing on themselves is something that it's kind of a monumental task. So kudos for them for, starting this journey and then connecting with you to provide that help. And Kim, do you want to talk a little bit about your involvement with the family?
Sure. Justin, I'm going to put you down a little bit there. Well, first of all, I do want to clarify. I worked with SEAC for about 1.5 years just recently, but over the last 13 years, I've done this all beyond that as all my advocacy has been volunteer. So that was just a short little stint, but wonderful organization, Erin Richardson heading that up. But I did that for a little bit. They wanted to go into East Tennessee. So from the get-go, I've just done this. I had to advocate for my own son. And when I saw other students at our elementary school, a wonderful elementary school, but they shipped everyone out to the inclusion school, as they would say, oh, your kid will have to go there. We don't have the resources. Well, I had come from Richmond, Virginia, where I had a crazy mom like me who advocated, and she was Vicki Beattie in Richmond, Virginia, was my Kim Kredich then to Deborah and Greg. And so I started alerting them as to the rights that Luka had. And I just, I helped them get the full-time education, inclusive education for kindergarten. That then, then it was sort of a sad moment for me because they said, and Deborah said, sort of ironically, Kim, I don't want to have your life. I don't want to be fighting this. I'm going to go to Chattanooga. And I thought, okay. So, of course, then she ends up in 5 years of litigation. So she kind of got, a different version of my life as well. But she was able to go, they were able to go to Chattanooga with the Stay Put IEP being full inclusion. And I think I'm very happy that we were able to put that in place for them, because that set up a few great years in Chattanooga at Normal Park. It was all like sunshine and rainbows from what she'd text me. And then things went sour that year that the school decided he has hit a wall or we can't do it. He's not keeping up. And I think Justin can really talk to those points, that it was just it was such a clear-cut case, especially because they were moving him to a different school completely for a program that didn't even have a peer-reviewed curriculum. And so there were a lot of things in place. And Deborah, let me just say, yes, I'm an advocate, and I've helped support the case by consulting about issues of inclusion and state-specific rules. But Deborah did not need an advocate. She is it. She's amazing. She did all the IEP meetings. She represented herself. So my role, even though I was their advocate back in Knoxville, changed to more, I am on the team helping the attorneys, especially with my bigger knowledge maybe of having gone into maybe hundreds of IEP meetings at this time. I've helped about 300 kids around here. So I had that angle, and we all just made this amazing team, and it's been an incredible journey right up to Monday.
Oh, I bet. And I know when I was reading the court decision that the principal at Luka's school was saying, yes, he did benefit from being in the regular classroom for, first and second grade. But as you said, Kim, it's like, oh, he's hit a wall. He's not, keeping up with his peers. And I think, because so many students start having to take state tests in third grade, that's kind of a way, or kind of almost a milestone where students that had been included previously are now, the IEP team might be recommending a more segregated placement. And it sounds like that was part of the case. And I know, Justin, that for a lot of families, they will hear that pushback of, your child can't keep up. They're not meeting the grade level standards. So as an attorney, how do you approach that, or how do you look at that and, have an argument back to the IEP team?
Well, ultimately, that was one of our strongest grounds in the case. They would write in their IEP meeting notes that they did not believe Luka was keeping up, that he was not mastering the curriculum, that he could not meet the third grade curriculum like his peers. And so when I read that, and I read it not only in IEP meeting notes, but I also saw it in affidavits of staff. When I read that, I knew that they were holding him to almost an impossible standard for a little boy with Down syndrome. And I knew that that could not be the standard. And so from a legal standpoint, that was more of a legal issue than it was a factual issue. In other words, it dealt with a legal standard. And so when we went into court, it was helpful for us to be able to tell the judge, the district is applying the wrong standard for him to be included or for him to remain mainstreamed. And of course, we pointed out that the whole purpose of IEP goals are that they're to be uniquely tailored to his present levels. We pointed out that the IEP can last through age 22. So there's a presumption that he need not move as quickly as his peers. And the district court understood that. A lot of judges are not familiar with the IEP process. Some of them, frankly, I think get intimidated by some of the educational words. But judges are very familiar with legal standards. And there is some case law that talks about how children with disabilities are not to be held to a mastery standard or an on par standard. And so we used that groundswell of cases with our district judge. And ultimately, I would say that was our strongest plank in the win. And he delivered a very good opinion at the trial court or district court level about how he does not need to compete with non-disabled peers merely to be mainstreamed.
Wow. And I know that one of the cases that you had talked about was the Andrew F. case out of Colorado. And that had, we had gotten that Supreme Court decision. And I just wanted to remind viewers that, if they want to get a copy of this decision, just to type the word decision in the comments and you'll get a link to it. We do have a question from Aaron, and he says, what does this decision mean for students in other areas of the country not covered by this court?
That's a good question. The courts are essentially divided into regions of the country, and our region is known as the Sixth Circuit. And our region covers Tennessee, Kentucky, Ohio, and Michigan. And so for those states, this is a mandatory and binding decision. It is precedential. Now, for other states outside of those four, it is not mandatory and binding, but certainly it's influential. And in the law, it's called persuasive authority. So if you have a case similar to the Luka case in other states, your lawyer would certainly want to cite to this case and say this is persuasive authority and it should be adopted by our court. In fact, in other regions of the country, this decision is complementary, so there's no reason that I know of that a court would not consider this persuasively.
And I think that's the great news, is that, you know, even though there's a little bit of a difference, but we certainly can look to the Sixth Circuit Court decision and use that when, you know, we're advocating for our kids to be included in general ed classrooms. I know Courtney Hansen, who has written a few different blog posts about this case, she wasn't able to be here with us today, but one of the questions she wanted me to ask is, how can parents who can't afford to hire an advocate or an attorney use this ruling to get FAPE in the least restrictive environment for their child?
Well, I'm going to toss that one to Kim, because that's something that we discuss a lot, is the cost of lawyer services and advocacy services. But I think there are online resources and information that's available to the public, and hopefully this opinion can be easily accessed. But I bet Kim has to wrestle with that question on the front end quite a bit.
Yeah, well, that's part of why I do this for free. It's my unfortunate hobby, as I call it. And, you know, I saw what I had to go through, and I wasn't able to afford you know, any kind of help. But I had to give up my own career as a musician. So I didn't want anybody else to have to do that, I will just say. It became a full-time job to secure inclusive education for my own son, Ben, and I have 3 boys, and everybody's different. I will say, you know, I didn't want to take him to put him in even private. Luka's an only child. Ben has a twin and a younger brother. So every situation is different. And sometimes it's safer at school when there are siblings there with eyes on what's going on. You know what I mean? So I take every situation differently. And what you can do is really look at, you know, Paula Cluth and Dr. Julie Coston are my heroines. They are just so wonderful. They have podcasts, and there's Think Inclusive, there's you. You can really learn a lot. What I find is that most parents aren't aware of what's going on. And that was the case with Deborah and Greg. Honestly, they didn't know. You want to trust the experts. They've got your child in school. So I think that's the biggest issue, is awareness of your child's rights. And I think that the more we can do to get out there, you know, for example, as you know, the way I figured it out, because I'm an artsy person, is, okay, let's make a documentary so that we can show to any Joe on the street this 25-minute documentary, and they'll say, oh, right, I get it. Everybody should be included. And that's a way of getting it out there to the public. So first they have to know that their rights, what their rights are, and that they're not being met. And then look at all those resources. And with the internet, you can really find so much. So I would just say, really use the resources that are free around you, and really look at rights law and all these other places that can benefit, you know, that will cite a case just like Luka Hyde. and that will say, well, he's got it, so why can't my kid have it? I always call that the Harry met Sally thing, like, well, I'll have what she's having. And I tell parents right at the beginning, well, you should be mad at me for not getting what I had. I said, like, what? I'm paying the same taxes as you. Why did my kid get a one-on-one aid and do so well and is now at a post-secondary certificate program at the University of Tennessee? Those are now new. Those can be the goals. I know it's the goal for Luka to go to someplace like UT Future or Vanderbilt Next Steps, or UT Chattanooga has the Mosaic program. I mean, the sky's the limit at that child's level. They can go to college, experience that, live as independently as possible. So there's just a lot of great news out there. We want to get it out there. We don't want this. This is part of why we're on here. Just spread it to the masses.
Oh, exactly. And if people want to click the share button, and you can share this to your own Facebook page. So the documentary that Kim was talking about is, you can see the trailer that they have now on YouTube. If you just type in on the YouTube search, Push into the Swell. And this is a tremendous, helpful documentary that will make an impact on a lot of families and I think educators. And
Charmaine, let me say that it'll look like it's just about inclusive surfing, because that was sort of the point. I mean, we talk about, hey, if you can modify and accommodate to get all these kids, including Luka. There's great footage of Luka and Deborah talking. This was 3 years ago when we started filming this. And but what it actually turned into was following certain families, including Luka's, and it'll be much more about the stories of these families. But we use surfing as an analogy or metaphor or whatever to show, hey, don't leave these kids on the sand. Provide them the support, the accommodations, modifications, supplementary supports, specialized instruction, everything that is like a general ed classroom. If you can get a kid with a significant disability to surf, or on a surfboard, even on their knees, on their stomach, how come you can't do that in the classroom? Because most people haven't surfed before. In fact, Justin, I'm going to out you. We even got Justin on a surfboard that first year. It wasn't pretty, but it was
not pretty.
Well, and Cheryl is with us from Pennsylvania, and she said that parents can also contact the National Down Syndrome Society, and I know the National Down Syndrome Congress. They offer lots of advocacy resources. And Erin had a website, which is a great place that you can find additional resources. So it's the kit.org website. And Cheryl had a comment here. She said that districts spend so much time working to make our kids look incapable, and that is so scary. How can we prevent that?
You want to take that, Jess? I mean, I've got some ideas about that.
Well, I'll touch on it just
sure.
briefly, and then Kim probably does have a better answer. I think that if you are going to consider due process, pick your best issues. A lot of times when parents come to me, they may have a dozen issues, and they may be right on all 12, but that can overwhelm a judge. And so I would say pick your best issues. And a lot of times I see teachers become angry with parents because the teachers themselves feel threatened. And they may be teachers who have not gotten a lot of credit, who perceive that they're working hard without any feedback. So when they get criticism, it's taken particularly personally. So hopefully before you get to the point of where the teacher is documenting all kinds of perceived negative behaviors, there can be some diplomacy. So I guess my 2 points would be a whole lot of diplomacy on the front end. If you do have to go to due process, pick your best legal issues. Don't flood the courtroom.
And I'll just piggyback on that, that especially having to do with this case, what I see is that a lot of the times the reason the schools say they can't do it, look at this behavior, is that they're not understanding the law, which I think this opinion and Judge Collier's opinion does such a good job to come into the sunlight, which is a ladder. I think Judge Collier used this great ladder description.
That's the trial judge.
Yes, the trial judge, exactly. And that you start wherever you are. That's present levels, as we all know from IEPs. And then you've got to modify, and you've got to accommodate, and you've got to support. And if you don't do that, any one of us, if we're not supported in something we have trouble doing, well, we're going to behave a certain way. And so what I find is that sometimes schools will even, and they did this in our case, I will say that, they even knew the right buttons to push which is, way in the past. And it was the general ed teachers who came to the rescue, honestly, because they worked with me at risk of their own employment, I will say. I mean, you can always find phenomenal general education teachers and special education teachers in general. There are some people who went into this business to only have a class full of their kids. And that's a tough one because that's not what the law said. I mean, that should be the last resort. So that's where you find the resistance. You've got funding issues. There are so many things that are swirling around this one kid who just needs to be included. And that's where I find partnering with, being a part of a team on this case and many others with Justin or several other really important cases, you've got to dig a little deeper and figure out what the root cause of this issue really is. Is it the funding mechanism is set up to incentivize restrictive placements? Is it they didn't have a proper behavior plan, or they weren't addressing it? A lot of times it's they're not supporting, they're not modifying the content. They don't even understand that. And that's what I think the judge in the Sixth Circuit Court really, sort of spanked the district for not having the tools to believe in, never mind implement the letter of the law that was already there. This just put an exclamation mark on it, I think, and really explained very well to people what is supposed to be done.
Well, and I think it's also interesting that at the district court level, they ruled that, yes, they thought that this segregated school that the district wanted to move Luka to was more restrictive. But on the other hand, they were saying the Montessori school that his parents placed him in did not meet the criteria to, under IDEA, so the parents would not be reimbursed for the tuition and the cost of the Montessori school. And then it was like both parties appealed that. So if you want to talk, Justin, a little bit about how that came about, and then, the kind of some of the decisions that were made in the Sixth Circuit Court.
Sure. One of our challenges with this case is that we were dealing with three separate schools and three separate placements. The parents were arguing for the regular education public school classroom. The district was arguing for this segregated public school classroom at a totally different school. And when they were at loggerheads over that, the parents privately placed Luka in a private Montessori school. And so while we were thrilled to win the LRE issue, that is, we won on the issue that the parents were right about the public regular school classroom, we initially did not win the remedy. That is, the remedy of reimbursement of the private school. And the reason we didn't win it, at least initially, was the school system argued to the trial judge that Montessori was too unstructured and scattered, and therefore his needs were not being met there. The trial court accepted that and denied reimbursement. So you're quite right. We also had to appeal to the Sixth Circuit. And our appeal was that, hey, wait a minute, this Montessori school is meeting his needs. And that's one really nice feature of the Sixth Circuit opinion. They did overturn the trial judge, and they found that the Montessori school is different than the public school, certainly, but that's not to say that it is just loosey-goosey unstructured. In fact, he had a very tailored program to his needs. He had a one-on-one aide. He had an additional classroom aide that the Montessori school already provided. The curriculum was tied to the state standards. And so that setting, the Montessori setting, did in fact meet his needs. And the Sixth Circuit did a very nice job of explaining that and awarding the family reimbursement.
Yeah, and Charmaine, I'll just add in that we've actually got, as part of that documentary, we went into the Montessori school and we've got footage of Luka in there with his supports, with all the other kids. We've got interviews with the director of the Montessori school. I mean, it's, you know, you follow a case along and you know it's meaningful, and of course the Hydes are my friends, so but to get this, to have been in that Montessori school, see Luka progressing, working, it sure looked very structured to me. I mean, I love the Montessori method. I love public school. I love anything that that serves the child well, to educate. And I think everybody will be able to see, not just from this opinion, but I'm hoping they see with their own eyes. Look, this is when parents go to due process, this is an option if you have to be able to afford it, though. But look at that. I mean, now they're going to get reimbursed. And the district was the one who appealed the decision. And then the Hydes cross-appealed, saying, okay, well, we're going to go back to court. How about we go for that reimbursement, because we really think the judge made an error. If we're going to go all the way up to Cincinnati, let's cross-appeal and put everything back on the table.
Well, and that was one of the questions, Justin, that Courtney Hansen had is, do you know, can you predict if the district will appeal this to the Supreme Court?
Well, of course I don't know, because that's a private meeting among their lawyer and that the school board, I guess. But it would surprise me. The opinion was so thoroughly reasoned, it was unanimous, and there is nothing in the opinion that I think would cause the Supreme Court any concern. I'll also add that this case has sort of galvanized our local community to become more inclusive. So I'm hopeful that they would not appeal it. I will add, though, that just because you want to appeal to the Supreme Court doesn't mean you get to appeal. They are very, very selective on the cases they take. Well over 95% are declined. So if they appeal, it would actually be a request for permission to appeal, and only if that is granted would they get to appeal. And I would be stunned if the Supreme Court would accept an appeal based on the thoroughly reasoned decision of the Sixth Circuit. Hope that's not too wordy of an answer, but all of that is to say it would surprise me if they do, but if they do, I think it would be very unlikely to succeed.
Right. And Courtney also asked a follow-up question. She said, what is it going to take to get the Supreme Court to take up a case specifically about LRE like this one? Not following the continuum of placement is the biggest barrier to FAPE for kids with Down syndrome and other significant disabilities. She says, will the Supreme Court ever back the language of IDEA and force these districts to follow the letter of the law?
Wow, that I think about that every darn day, especially, right after this, I'm going to my 5th IEP meeting of the week, and it is so complex. I think, Justin, when you got into more special ed law, as much experience as you had as an attorney, you were overwhelmed by the intricacies of this particular field of law. So I'm going to hand that. With that, I'll hand it to Justin.
Well, I don't know when
I think you turned the volume down, Kim.
I got it. I'm turning it up.
Yeah. I don't know when the Supreme Court will dive into that issue. Normally, they take cases where there is conflict among the circuits. So, for example, if a court from a different circuit were to reach a different conclusion in a similar case as Luka's case, that would set up a conflict that the Supreme Court might take. But until that happens, courts do have to follow precedent of a higher court. So the decision that we have in Luka's case, that is the precedent of Kentucky, Michigan, Ohio, and Tennessee. And it is just as binding as a Supreme Court decision. So I guess I would say until the Supreme Court takes that issue up, rely on the language of the IDEA itself and rely on cases like our Luka case.
And I also wonder about the Andrew F. case, because that was a Supreme Court decision, and I know it was cited in your case here, but I don't know, Justin, if you have any additional things that you might want to say about the Andrew case in LRE.
Well, Andrew F., of course, deals with what is an appropriate education. And it's helpful in the LRE context, I think, in this sense. It talks about how children are entitled to an ambitious education. It talks about how they're entitled to rigor. And where do you find that? You find that typically in the regular education classroom. You find that in the least restrictive environment. So one way we were able to use Andrew F. is to contrast what Luka would have received in the regular education program. That is a rigorous, ambitious program consistent with Andrew F. versus the classroom that they wanted to put him in. We were able to argue that was curriculum-less. It had no state standards. It had no peer-reviewed program. It had a totally different location. It did not offer any benefits of learning from non-disabled peers. So we were able to say how the district thinks that would provide him faith is beyond us. It's certainly not consistent with the ambitions of Andrew F.
Right. And Cheryl from Pennsylvania is saying it's interesting because we feel that, let me see, I just lost that. Where did it go?
Feel that the districts can still find loopholes in determining capability of kids. Yeah.
Yeah, so I mean, I think that is always something that we deal with as advocates and, attorneys, as far as, districts finding that little loophole or having some really generic language in the IEP where they can kind of slide and get away with things. So I think having a well-written IEP is going to be paramount to making sure that your student gets the education that they deserve. But having a well-written IEP is half of it. The next part is to make sure it gets implemented with fidelity. And that's where I think that persistent parent advocacy is going to come to play.
And Charmaine, I'll just say that I look for especially, I don't advertise, I just get my number passed around, and I get so many emails, and I vowed to help every single person that contacted me. So this is 13 years later, and I've got more and more people. But Justin can attest to this. The reason, I couldn't do it on my own. I thought, you know what? Once my kid is included and he succeeds, everybody will see it worked. Well, that was a little bit naive because he did succeed, and it seemed like they dug their heels in more for other kids to have those opportunities to succeed as per the law. But what I did look at was I was getting all these calls, and I could look at systemic issues. And the first one I really tackled was the pre-K LRE. And our district, the people didn't even understand. They said, oh, but preschool is voluntary. And I said, well, not for the law. You've got to start at 3 years old. So they even had the facts wrong, the people who were in charge of it. And I'm happy to say that just 3 years ago, after 10 years of saying, even going to mediation, going to all these IEP meetings, I get tons of calls about preschool LRE. Our system finally implemented inclusive preschool classes in 11 schools. And I point out they didn't have to, but they did have to then privately place students at, a private preschool if that was the LRE. The district doesn't have to provide that, or through Head Start. I just wasn't seeing what could be. And so tackling those systemic issues, now I don't get any calls about preschool because, and I'm not saying I did it, single-handedly. I think that OSEP weighed in and I brought it to their attention. So somehow it worked, and I just want to work my way out of this hobby. So the more I can do that, like the funding issue, being transferred out of zone for medication, isolation and restraints, like we're really, I see all of these, and then I pull together a group of parents who are willing to fight the good fight. It doesn't just have to be a crazy advocate like me who says, I will answer every call. I will go to every IEP meeting, even though they are just sometimes the worst things in the world. And if they're not, then why did I have to be there? But, other parents can support efforts for systemic change. I get up in front of that school board all the time. For one point, I was going to every school board meeting, and I figured, well, they got to listen to me for 5 minutes. I called it your 5 minutes of special cred. I was like, I'm going to just bring forth a point and educate the school board. And unfortunately, it just didn't have the impact that I had hoped. And, I told them a long time ago, look, I'm not going to sue, but other people are going to start to file lawsuits. And then through the Hyde case, that's, Justin was getting contacted just from people in Knox County. And there are several cases that now we've worked together on with that are pending or have settled with wonderful results for everybody. That's the point. The parents, in many cases, aren't doing this to, remedy specifically their situation. They recognize that they don't want other people to have to go through those things too.
Oh, exactly. And go ahead, Justin.
I was just going to add one thing to Cheryl's comment about the district still finding loopholes. One nice thing about the LH decision that we just received is there's a nice section in there that talks about teachers are not the sole judges of the child's education. And so often you go into a due process hearing or an IEP meeting and the teachers say, hey, we are with the child every day. We are the experts. Defer to us. And even in our case, that theme, it ran throughout. And I remember when we were in the United States Court of Appeals for the Sixth Circuit, that same theme was argued by the district. And Judge Batchelder, who wrote our opinion, said, are you saying there's no room for disagreements? Are you saying there's no room for parents or experts? And sure enough, in the opinion she writes, she talks about how parents are just as much, if not more, of an expert on their own child. And just because the teachers see things one way does not mean that courts must defer to them. And so it's a really nice, a bit of a pushback, so that if you have a good expert that can talk about the child, that should be heard by the courts going forward.
Yes. And I think, again, let's see, Debbie is here, and she was asking that she came in late and is it being recorded? And yes, the replay for this live show will be up on my Facebook page and stay there. So invite other people that weren't able to be with us live, know that the replay will be there for you to watch. And Debbie, if you want a copy of the circuit court decision, just type the word decision in the comments, and we'll send you the link so you can actually read it for yourself. And I'm going to be writing a perspective from an advocate point of view, because I'm not an attorney and I can't give you legal advice or, interpretation, but I am going to be writing a short ebook about this and how parents can use this as they advocate for their kids. So type in the word decision and you'll get those links. And I also wanted to go back to one of the comments that Kim had made as far as, inclusive preschools and making more systemic change. My son is 29, has Down syndrome. We filed for due process when he was 3 over the issue of LRE for preschool. And luckily, we were able to settle at mediation, and the district did support him going to a community preschool in our town instead of the special ed preschool. And that created a lot of opportunities for other families. But what made me so, sad is when I looked about, 10, 15 years later, and I was going to other, IEP meetings with families, that option of community preschool disappeared from the table. And so as we blaze these trails for other families coming after us, we have to know that that trail can become overgrown quite quickly. And we do need to have that persistent advocacy in order to create that systemic change. So I just encourage families to partner with other parents or other support groups to keep going, because it is very emotionally, financially draining. And there will be times that you want to give up and say enough is enough. And we just have to keep encouraging each other to continue this road that we're on.
I agree. And it's just, that's when I say, find your, people say, find your passion. Well, I thought I had, it was music, and I still absolutely love music. I really did undergrad and graduate work, and I was I taught, and going into conducting, and then to find, I remember I said it in front of the school board, because they know I'm a music teacher. I should have been teaching in Knox County. I love public school teaching. And here I was just saying, wait, there's something even more important, oh my gosh, than music. And that is all kids' experiences. I mean, I put together even a grant-funded exceptional orchestra, an inclusive orchestra that the Hydes were in. Luka was in. He just loved it. But that was 6 weeks. And people would say, oh my gosh, this is the most inclusive thing we've done. And I thought, well, but then it went away. And what is their life for their entire schooling from age 3 to potentially 22 and then beyond, with all these wonderful post-secondary opportunities? And I thought, 7 hours a day in, surrounded by peers, general curriculum at their level, that is what my passion became. And also through partners in policymaking. I should point out that Deborah Rausch, now is Luka's mom, is a graduate. And it was funny because we hadn't been in touch for a little bit. During that time, she said, hey, Kim, have you heard of this? I was like, yeah, I was a 2004 graduate in Richmond, Virginia, back when we lived there. Those are programs that are funded by federally funded to help train parents to advocate. And it is the expectation when you get these once a month little seminars that you go out and you advocate. And I took that pledge very seriously, obviously, and that has just guided my life. And, you know, I don't think I'd rather be the person I was rather than the person I am now, just because that's always been my personality. But when you have a kid with a disability, people say, oh, it changes you. And I'm like, no, it just sort of shows you what you got, you know. But as I say, not everybody wants to put their lives, you know, towards something, but support the people and the efforts that do, so that we're all working together. Everybody can do something towards this effort.
Oh, exactly. And Patsy is with us live from Colorado, and she says, we have been successful in getting our son Connor included in the general ed classroom. We have not always been successful in getting meaningful inclusion. Modifications to general ed curriculum and big idea teaching so he can keep up hardly ever happens. Does this decision address this? Sometimes I feel leaving him to struggle is on purpose to show that he doesn't belong in the general ed classroom.
The district court decision does discuss that to some degree. It uses the ladder analogy to talk about he does not have to be at the same level as non-disabled peers. He doesn't have to be on the roof. Where he is, which rung of the ladder he is on, is just fine. But Patsy makes a good point, and I think we would do well to recognize that a lot of inclusion is attitudinal. And if the teachers are hell-bent to show, look, the child can't do it and I'll prove it, then that can be borne out in the classroom, and that's very stressful on the parent, and it's just a shame to do that to a child. And I have seen that. Hopefully, with more decisions like the LH decision, we'll see those attitudes drift away. But it is very possible for this "I told you so" attitude to occur in a classroom, and if you think that attitude will not change, you may want to ask for a different teacher.
Yeah, and I know that a lot of times parents aren't aware that you can write in training for staff into the IEP under the supplemental services and aids. And when I'm working with families, I really advise them to look for real specific language, because what I've seen in the past is, you know, it will be training will be provided, you know, to the teachers, and they do a 1 hour workshop or hand out an article and say we trained our teachers. So I think it's really important to be specific and to make sure that there's some ongoing coaching for teachers, because if they just have a workshop, we know that most of the time 0% of that workshop will get implemented unless they have that ongoing coaching happening. So, you know, sometimes if you're in a school building and they're not really providing that meaningful inclusion, you can look to other buildings in your district that are doing inclusion in a quality way, and maybe have some of those teachers come over and help train. You know, teachers are more willing to hear advice from a peer sometimes than from a parent. So that can be a helpful strategy that they can use too.
Yeah, and I think that the key term is student specific. So that means bring in I've always found that the most effective student specific training, you know, situations are at the beginning of the year, whether, let's say in high school, we had that for sure because he was transitioning from middle school to high school. All the teachers came in. We came in. They got to meet Ben. They got to meet his brothers. They got to ask us any questions. You know, we didn't pretend to run the training session, but bring all those people, send emails that they to the teachers. The parents should be able to say, you can contact his cello teacher, his swim coach, or just even little informational tidbits of he, you know, really likes the rock band Queen and he's interested in the, you know, French language and little things, just to give them a little tidbit. That's what teachers want to hold on to. They want to see every child bloom. I have such faith in the teaching profession that if you can unlock with a little tidbit of information something that hooks that teacher to that kid, and I've seen it over and over and over, with not just me, but make that connection with the teacher and make it as personal to the kid as possible. And other, therapists, get them to write in, but it really, the parents' passion and even siblings, then they become part of the magic of inclusion. A lot of the stuff that happens in inclusion is not written on an IEP, I can tell you that. There's no birthday parties invited to, written that he will be invited to Jimmy's birthday party. I get pictures galore saying, look at this, first birthday party ever invited to. And that is just a beautiful byproduct of being included in one's public school to the maximum extent possible.
Oh, that's for sure. And I know that some of the things that we did with our son Dylan was not only to invite his brother or sister and their input, but also friends to come to the IEP meeting. And the other students would often have much better ideas about, suggestions for accommodations or modifications for Dylan. And so sometimes that thinking outside of the box is what's going to make a difference. And when teachers hear it out of the mouths of other students, out of Dylan's mouth, it does cause them pause to sit back and think about, this does sound possible. I think we can actually get this implemented. I know we're almost at the hour here, and I know that Kim, like she said, has another IEP meeting to go to, and Justin has been doing lots of interviews. I did want to share a couple more comments here from people. Debbie is saying that she's a non-confrontational person, and I would much rather not be in this situation. And she says, yes, I want to give up already. And Kelly says, Debbie, I'm right here with you. I'm not confrontational either, but our district is teaching me to be, because they aren't giving our daughter a fair education. And so I would encourage folks, we've listed in comments here several different options as far as other resources. I do a weekly Facebook Live show where just recently we did have Paula Kluth and Julie Costin on talking about co-teaching. So I encourage you to like my Visions and Voices Together page. We are here every Thursday with a Facebook Live show and do provide a wealth of resources for you. But Justin and Kim, what final words would you like to leave us with as we are closing out our show here?
Well, I guess thanks for having me on, and it's great to talk to your community. I hope this decision helps kids across the country, certainly in the Sixth Circuit, without having to go through due process, without having to hire a lawyer. If you do have to do that, I would encourage you to contrast the least restrictive setting, the regular education program, in some detail with the alternative setting that the school is asking for. And when I say in some detail, I mean go through the number of hours of inclusion, if any, that the child would get in the alternative setting. Go through the curriculum. Would it be an alternative curriculum altogether? Is it tied to any state standards? Is it at a different school entirely? Those kinds of details and those kinds of contrasts will help you win that decision. The LH decision does a nice job of setting forth the contrast right at the beginning. And so if you're going to try to explain what can sometimes be a bit of a complex matter to a due process hearing officer or even a judge who's not familiar with this stuff, make as many contrasts as you can. That would be my final piece of advice, I guess.
And I would say that a parent like Deborah, especially, I mean, I just can't say enough about her and people who take things to the end, to the very end. And it is so, her life changed, you know, as mine did. When you become a parent, you don't expect your child to have a disability. And when that happens, it is a profound change in what everything you expected and everything you knew. But it's a part of our, you know, natural life. This is what parenting is about. I call it extreme parenting. And the impact that you can have on so many people that you don't even realize just by that mama bear or papa bear parent coming out and doing what you need to do. And it's not like that's the fun thing to do, but, you know, I look at all the great advocates in this, our history, look at Rosa Parks. Well, why didn't she just move up north where she didn't have to, you know, or what, you know, just look at the people we so admire. And so I just wanted to say, having seen Deborah, it's different from afar. When I advocate, sure, I advocated for my own kid, and that was just so different from advocating for other people's kids because it's not my kid. I'm doing the best for them, but that is truly a blessing and a curse of just becoming a parent. You go for it, or you find somebody that you can partner with who balances out your style. If it's non-confrontational, find somebody who's willing to take all the knowledge you have and put it on the table in front to present it. Figure out what you can do and find help with what you don't feel comfortable doing.
Oh, I think that's excellent advice, because we all as parents don't just want our kids having a seat in the general ed classroom, but we want them to be learning every day side by side their friends. Right. And we want students to stay in their zone, stay in their neighborhood schools, and have the opportunity to go to the school that their brothers and sisters go to, that their neighbors go to. And so I'm so thrilled that we were able to have both of you with us today. I also want to let people know that next Thursday, our guest is going to be Candace Cortiglia from the Advocacy Institute in Washington, D.C., and she's going to be talking about filing systemic state complaints as a way of creating more change in our schools. So thank you, Kim and Justin, again for being with us today. And I am Charmaine Tanner, and I will see you next Thursday at noon Mountain Time. Take care.
All right. Thank you, Charmaine.
Thank you.